So the petitioners who prevailed in the disqualification case under the 14th Amendment, Section 3 before the Colorado Supreme Court, they have finally filed their petition for writ of certiorari, or more specifically styled as their respondent's brief in response to Donald Trump's petition for certiorari before the United States Supreme Court. In essence, the Colorado Supreme Court ruled that Donald Trump was disqualified from the Colorado ballot. They gave Donald Trump until January 4th to file a writ of certiorari, or an appeal to the United States Supreme Court. Donald Trump did that at the last minute. The Colorado Republican Party filed their petition for certiorari before Donald Trump, and now the petitioners from the Colorado case, represented by the organization known as CREW, and this group of petitioners is referred to as the Anderson petitioners. They filed their response to the United States Supreme Court. Now, at this stage, the petition for certiorari is not actually the argument that are going to be made specifically before the Supreme Court at oral argument. They, don't get me wrong, petitions for certiorari contain that because they have to explain why these legal issues are so pressing and important for the Supreme Court to hear it. But the petition is basically asking the Supreme Court, can you please hear this important issue? Is it an issue of where there's a circuit court split? Is it involving some constitutional crisis? Is it of national import? Why should the Supreme Court hear this? So Trump argued they need to hear this because obviously it involves some important questions involving the United States Constitution and Colorado law. The Colorado Republican Party argued that. And here the Anderson petitioners, they filed their petition and they said, look, we think the Supreme Court should hear it, but not on this hodgepodge of issues that Donald Trump tries to lump into a simple question. The way it's framed by the petitioners here, by the Anderson plaintiffs, it actually involves a number of discrete questions that the Supreme Court should ultimately answer. And here's how they frame it here. It says, the Anderson respondents agree that the Supreme Court should grant certiorari, that just means to hear oral argument. As explained more fully in their response to the Colorado Republican Party's position, the weighty 14th Amendment questions here warrant the court's attention, even in the absence of a split, a circuit court split. And this case presents an ideal vehicle for resolving them. However, the court should grant certiorari on discrete issues rather than on the indiscriminate hodgepodge of legal and factual issues raised in Trump's petition. As properly framed, this case presents 5 questions, the Anderson petitioners say, that warrant this court's attention, 2 of which overlap with questions presented to the Colorado Republicans' petition. Then they go and they state what these 5 questions are, discrete questions that the Supreme Court should answer, and what they say the Supreme Court should not delve into is Colorado state law, because the Colorado state election procedures is not within the province of the Supreme Court's, really the Supreme Court's jurisdiction. That's a states' rights issue, how the local election laws are carried out. Yes, the supremacy clause of the Constitution allows the Supreme Court to resolve any disputes where a federal question or a federal issue conflicts with a state law, and the Supreme Court's the final word, the Supreme Court of all of the United States, including state courts, when it comes to federal interpretation, but not how the intricacies of state law. So one of the things CREW says is, you're not here to interpret Colorado state law, so stay out of that. The second thing CREW says is, Supreme Court, Donald Trump's been found to be an insurrectionist by the Colorado Supreme Court. Those are findings that were also made by the trial court judge after a extensive trial in fact. So Supreme Court, your job is not to relitigate whether Donald Trump was an insurrectionist. He is decidedly an insurrectionist, as determined by the Colorado Supreme Court, as well as the trial court. And you shouldn't be involved in any of that. I know Donald Trump wants you to believe that he wasn't an insurrectionist. He's an insurrectionist. That's a finding that you can't touch according to this petition for certiorari. But the 5 issues we want you to address in this petition when you hear oral argument is focus on these 5 discrete issues. And this is how it's framed by the petitioners. Whether a challenge to the constitutional qualifications of a candidate for president presents a non-justiciable political question. Pause right there. One of the things Donald Trump argues is that this is not for the courts, that this is the elections are the exclusive role, not even of the states, not of the courts, but of Congress is the one who can finally resolve all of these issues, which seems to cut directly against the power of state legislatures, as well as the power of states to set their election procedures. And that's one of the rights reserved to states under the 10th Amendment. But that's issue 1. But Trump says non-justiciable. Courts don't have any authority over this. The only people who can resolve this is Congress deciding 14th Amendment disqualifications. States can't set their own rules. 2. Whether the presidency and the president fall within the list of offices and officers to which Section 3 of the 14th Amendment applies. And you'll recall Donald Trump argues that he is not an officer, and Donald Trump says that he did not take an oath to support the United States Constitution. 3. Whether states may exclude from the ballot candidates who are ineligible to hold office under Section 3 of the 14th Amendment, whether Congress must first pass legislation under Section 5 of the 14th Amendment before a state can enforce Section 3 of the 14th Amendment, even if state law provides a cause of action to enforce it. And that's one of the issues where the Colorado Supreme Court, just like the Secretary of State of Maine, found itself enforcing. And you don't need Congress to pass a law or Congress to reach this conclusion. 5, whether by intentionally mobilizing, inciting, and encouraging the violent attack on the United States Capitol on January 6, 2021, Trump engaged in insurrection against the Constitution for purposes of Section 3. And their crew, this organization, says you're not to engage in any extensive fact-finding, simply that Donald Trump engaged in the act of insurrection, but all of the conduct and facts that were found should remain undisturbed here. So then you go into some of the arguments that are being made as we delve a little bit deeper into this brief. And here's what's being argued. Nor is there anything about the concept of engaging in insurrection that eludes judicially discoverable and manageable standards. Interpreting and implying such provisions is precisely what courts do. The concept is far less elusive than due process and equal protection, 14th Amendment standards courts grapple with all the time. Chaos would ensue were the court to accept Trump's argument that the 12th or 20th Amendments grant Congress exclusive authority to determine presidential qualifications. Trump offers no explanation why anyone would design a system where voters must wait until after a presidential election is over before learning whether a candidate is qualified to hold office. This is a recipe for ensuring that events of January 6th become a regular part of American politics. Far better to allow states to hash out such issues on ballot access stage than after, because Trump argues that it's for Congress to determine upon the certification of the Electoral College whether someone's qualified. And here Crew's like, well, that makes no sense at all. It's like Congress, this is for the Secretary of States and for states' rights to determine. The brief goes on to say, as the Anderson respondents have explained, Section 3 applies to the president and the presidency because the president is an officer of the United States and swears an oath to, quote, preserve, protect, and defend the Constitution, which no doubt includes an obligation to support it. And while Trump argues that Section 3 does not cover the presidency because it is not an office under the United States, Even the Colorado Republican Party refused to make this dubious claim in a full-throated way. The Constitution repeatedly refers to the presidency as an office and requires the president to swear an oath of office before assuming the execution of his office. And again, remember, Donald Trump is arguing that he did not take an oath to support the Constitution. Just you can see the brief that he had filed right there with the Colorado Supreme Court. The Colorado Supreme Court argues in this petition correctly held that Section 3 may be enforced prior to an election and need not wait until a disqualified person takes office. Then Trump claims that the historical meaning of insurrection was limited to taking up arms and waging war upon the United States, but he cites not one source to support this claim. As this court has held, the Supreme Court has held, insurrection against a government may or may not culminate in an organized rebellion, but a civil war always begins by insurrection against the lawful authority of the government. Insurrection is thus necessarily less than civil war or full-scale rebellion. Instead, an insurrection refers to a rising of any body of people within the United States to attain or effect by force or violence any object of a great public nature, or to resist or to prevent by force or violence the execution of any statute of the United States. And that's what the petitioners are arguing here. They then say this court should, this is what I was saying earlier in the video, this court should deny questions that relitigate factual findings. Trump complains about the trial court's factual findings and the Colorado Supreme Court's holding that the record fully supports those findings, that Trump is an insurrectionist. So you see before, it's a bit technical, but these petitioners are saying, we are okay with you determining what an insurrection is, but we're not relitigating the facts about Donald Trump engaged in these facts, which then should fit to you, Supreme Court, reach this conclusion on what an insurrection ultimately is. But again, they go on to say, in finding by clear and convincing evidence that Trump engaged in insurrection, the trial court made detailed factual findings relying on multiple witnesses, including eyewitnesses to the events leading up to and on January 6th, videos of Trump's speeches and other political statements, including prior praise for political violence by his supporters, and Trump's admission that he knew his supporters listened to him like no one else, unrebutted expert testimony placing Trump's approach to political violence in context, and unrebutted evidence of Trump's intent while the mob attacked the Capitol and disrupted the peaceful transfer of power. These findings should not be disturbed for several reasons. First, the trial court cataloged a litany of specific incidents before January 6th, where Trump had encouraged political violence by his supporters and saw how his supporters responded to his encouragement. For example, the trial court found that in response to a barrage of harassment and violence threats by Trump supporters against state election officials after the 2020 election, Georgia election official Gabriel Sterling issued a public warning to Trump to stop inspiring people to commit potential acts of violence or someone is going to get killed. And then it goes on to talk about as well how Trump argues that he never explicitly told his supporters to enter the Capitol, that he did not use the precise words is irrelevant. In factual findings that this court, these are factual findings that this court should not reweigh. The trial court concluded that Trump's speech, when considered in context, incited imminent lawless violence and was intended as and was understood by the crowd as a call to arms. Trump's speech to the angry and armed crowd included explicit commands to violence, walk down to the Capitol, fight like hell, implicit commands like go by a very different set of rules, we're not going to let the election be certified, and tweets during and after the attack endorsing the assault. As the court found, Trump's words and deeds were the factual cause of the attack, and Trump endorsed and intended the actions of the mob. So there you have it, a powerful brief. I took a little more time on this video because I thought it was important for you to hear this full petition for certiorari and how it's more narrowly framed by these petitioners. But great work here by that organization crew. We've had their general counsel and executive director on here on the MeidasTouch network. They do a fantastic job there. And the courage of these Anderson petitioners who have been pushing and advancing these issues that are so fundamental to our democracy. There you have it. We will keep you posted on what the Supreme Court does next. They'll likely agree to hear certiorari, but we'll see. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch and have a great day.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.